Hello everyone and welcome to today's webinar. We hope you're doing well and want to thank you for joining us for today's presentation. I want to mention that we did receive a lot of pre-webinar attendee questions. I did pass them on to Sue. She has received them and reviewed them and plans to address those topics during the presentation. We have a lot of material to cover today and a lot of attendees, so if you have questions, we'd appreciate if you wait until the end of the presentation to type them in, as we feel confident we will answer your question during the presentation. However, if we don't get to your question during the live webinar or if you have follow-up questions, we will get you an answer afterwards. I did include a PDF copy of the slides in the credential email that you should have already received to join this webinar, and I will be resending a copy of that and any other materials after the webinar. I'm excited to welcome Sue Ross as our speaker today. If you've attended our GTEC conference or other NCBFA events in the past, I'm sure you already know her as she is a frequent and sought-after speaker in the industry. Sue is a partner at MSK in Los Angeles, where she chairs the firm's regulatory practice as well as the cybersecurity and privacy practice. She focuses on compliance, whether dealing with international trade or cybersecurity, and deals with regulatory, civil, and criminal issues. Sue has a wealth of experience and knowledge, so we are very excited to have her present for us on this important topic today. So without further delay, I will turn it over to her.
Thank you, Cece. So good morning or good afternoon, depending on which time zone you're in. I'm going to try to power through a lot of information and leave some time at the end for Q&A. As Cece said, we did get a lot of questions ahead of time, most of them focused on 4 or 5 basic issues, which I think I will have covered by the time we get to the end of the slides. I do have some that were not covered, and I'll try to get those through to those first, but let's get started. The title of this really should be what is going on with CBP and powers of attorney, because of the activity that's going on. And in fact, what it really means for all of us, whether you're a broker or a forwarder, is your power of attorney valid? Because that's the entree into you protecting yourself as much as possible on a lot of different levels, some of them the regulatory side, some of them the commercial side. So let me start with forwarders first, because oftentimes when you talk about powers of attorney, the forwarding side gets left out. ISF, AES, you need powers of attorney. There's really 2 questions, and these are common whether it's the forwarder or the brokerage side of the house. Who is validating the POA and when? And what process do you use to validate your POA? And here's the same questions for brokers. All too often what we see is somebody sends the power of attorney in, nobody looks at it, it goes in the file, something goes bad later, and then all of a sudden it comes out that the POA is incomplete. Or somebody looks at it and doesn't look at it carefully enough. So we know if you're a forwarder, you need a power of attorney if you're filing either on behalf of the US PPI or on behalf of the foreign PPI. We also know that the law still allows a forwarder to obtain a POA from an importer and issue a subagent POA to a customs broker. I will tell you, customs hates this, but the important thing is if you're a broker on the receiving end of one of those POAs, and this is true, we'll talk about the subagent POA or the more traditional broker-to-broker situation, you do want to make sure that you get a copy of the underlying POA. You do want to make sure that there is authorization to appoint a subagent before you get too far down the line. On the ISF side, of course, you need a POA of some sort. There's an argument to be made. It doesn't have to be the customs POA, but you do need something. And of course, the provision is in the customs regulations requiring it. And of course, we know that there's provisions in the regulations for the broker POA. And really, in the end, not only is this a question of do you have the right to act on behalf of your principal, but most of you use the signing of the POA to then also get the importer to, or the exporter in some cases, to accept other terms and conditions. And if the POA isn't valid, there's an argument to be made that their signature acknowledging other terms and conditions may be equally invalid. And this is especially true with the NCBFA terms and conditions that are so often subjected to that line above the signature line saying, I have received and acknowledge and agree to. All right, why did this come up now? And we know that the answer is a multitude of things. First of all, we're seeing broker audits again. We're also seeing a ton of inquiries by customs on the right to make entry. These are importer of record inquiries. These are not detentions. This is customs' way of getting around the 5-day issue. I was trying to be in this slide very polite in terms of the disconnect between the side of the house that licenses brokers and the rest of customs, which, to be polite about it, customs really doesn't understand what forwarders do, and they certainly don't understand what brokers do. And unfortunately, although moving the broker management offices to the centers was intended to enhance customs internal knowledge, that has not proven to be the case. Most of you have seen this particular bulletin. Before I get into it, I will tell you I sat through a broker audit recently, predating this memo, in which I listened to about as much mumbo jumbo as I have ever heard out of a broker management officer. In this particular instance, they had instructed the auditors to ask a licensed broker about the amount of time she was spending in a forwarding operation. And we, of course, know that if you have a broker license and that license supports the brokerage operation, and you work in another brokerage operation, asking about the amount of time spent and what you're doing and how you're doing is an appropriate inquiry. It's not when it comes to a forwarding operation. The other thing that came up was this is a typical situation that happens not just in LA, but in a lot of other places. Wife owns the brokerage, husband owns the forwarding. They do a lot of co-branding of things. Customs objected to the names on the building because they both showed, and the names on a truck that was co-owned by the two companies, where you had the forwarding name on the top and the brokerage name on the bottom. And when they tried to instruct the broker that that was incorrect, I pointed out that they were off base, asked them to come up with a guidance, a Federal Register notice, something in writing that Customs said that was not permitted. Of course, they couldn't. And then when we got the audit report, they accused the broker of what they called, quote unquote, commingling, which they conveniently failed to define. Now, we're supposed to be getting an updated audit report based upon not this bulletin, but the one that followed it. And we'll see whether they've fixed the problem. But it's very obvious that we have a problem in terms of the knowledge level of the broker management officers. And so you as brokers in particular need to be aware of that, keep that in mind, and make sure that you know the rules and you don't just simply accept whatever they tell you. All right, so like I said, most of you have seen this. This came out early in December. If you read this literally, what Customs ended up doing was essentially invalidating the NCBFA power of attorney form that most everybody uses. Now, what Customs was trying to say was that the name, legal designation, and address of the broker needed to be stated. And certainly the name does. The rest of it, no. The piece of it that followed was the reference to the Customs form, the reference to the 14132 language, most of which is inadequate to really make sure that you're empowered to do what you want and need to do. The only piece of it that was semi-accurate was the end of it, which was a suggestion, perhaps not as strong as the regulations are, but certainly you do need to validate who you're getting that POA from. The reason I said that it is partially correct is it's when they went through the examples, it becomes sole proprietor and partner, should have been or. Also, the requirement that it be in the corporate certification, which is actually not a requirement, and that the articles of incorporation are mentioned. And as most of you know, articles of incorporation or articles of formation or articles of operation or operating agreements, all that, they don't generally include the names of who's authorized to sign. The other thing that happened, if you notice, the last reference was to 141.3. I think they meant to refer to 141.38. And the language there about validating the person who executes the power of attorney is, of course, limited to a resident corporation. And while we have seen a few instances where who signed on behalf of a resident corporation is open to question, clearly the bigger problem has been the non-resident importer. And that wasn't really even addressed. So what we had happen was in January, there was a retraction published. Cece, is Dan joined us online?
Yes, Dan, I'm going to go ahead and unmute you now.
Yeah, please, because I want to give
Dan.
due regard to, sorry?
Oh, Dan's self-muted, so Dan, if you want to go ahead and unmute yourself, so
Please.
you can.
I want to give due regard to Dan Myler, because Dan was the one who really ran with this and was able to arrange for the C to issue the retraction. We are still kind of wondering what they actually mean, but Dan, if you want to take a minute and just sort of give a little background on this, please.
Well, we were surprised by that 21003, clearly out of line. The things they asked for, there's no place to put them on, even the power of attorney they referred to. What had happened was that in the regulations, they pulled out a format of a power of attorney, which really isn't a legal format. Go back to when we had the little half card of power of attorneys. It was different than what they put in the regulations. It's just where do you put the designation? It's that it threw us. So we went back and asked them to review that there wasn't any such that the language was incorrect. Went back to headquarters and they agreed. But then they came back and issued this second one, the 06. It's a very poorly written bulletin, I thought. It does, in the bulletin, they refers to 14144, which says, unless a power of attorney specifically authorized the agent to act thereunder at appropriate center and at all CBP ports. Well, the standard NCBFA power of attorney, we get authorization to act for them in the United States, which covers all the ports. So a lot of stuff that follows on that really should not apply. We're working on a letter back to them. We weren't sure how to properly request it, but we would like them to redo this bulletin, number one. Number two, the regulations that this one here looks like it was changed when they added the word center to all the regulations. And it looked like somebody just popped in the word centers in there rather than the ports. And nobody really looked at the fact that this is an obsolete regulation. I think back in I think it was the MOD Act, we're looking at that, or around that time, Customs came out and said, we don't want to validate your power of attorneys because it says you got to give it to the center, and they will look at it between all these regulations. So there's a lot of misunderstanding, like Sue said. And we think that the power of attorney, the key is we get the power of attorney, we validate it, and we keep it. And it shouldn't have to be presented to the center. And for a new importer, that's particularly hard because you get a new importer who's just starting up. They aren't designated to a center till we get the first couple entries because Customs assigns people to different centers. You know that when you see your 7501s, they have the same center team number for the entries for that importer. Am I saying enough for you, Sue? I wasn't.
Yeah, no, we're good. Thank you, Dan.
Yeah, it's just it is a problem.
And thank you for taking the lead on this. Here's the rest of what came out. And I think the issue for all of us is what the heck is Customs doing and what do they really want? And, for Customs to say Customs districts really was a little bit surprising. I mean, I think the message for this, by the way, is this was not vetted by the lawyers. I'm not saying it should have been. What I am saying to you is that people that wrote it didn't write it with the degree of precision it should have been written, as Dan said. And I'm going to make sure that Cece has copies of both of these notices so that any of you that have not seen them do have a copy. I do know from talking to some folks that the Customs Committee has looked at this and that Lenny Feldman is aware of all of this. And I don't know that anybody wants to make a really big deal about it, because it does seem to have quieted down. But I do think it's important to keep in mind that Customs is sending Forms 28 to importers. They're asking for broker POA copies. They are sending 28s to brokers asking for POA copies in the underlying validation records. Now, whether a 28 to a broker is the right way to ask for this is a whole other discussion, but it is going on. Customs is conducting these in-depth audits of various transactions, and they're asking for everything from beginning to end. They are looking at how brokers are vetting their powers of attorney. We have not seen this on the forwarding side. We have not seen situations, at least to this point, where there was a problem with a shipment and it has somehow traced itself back to some liability on the part of the forwarder for not having a valid power of attorney. But I also don't think it's unreasonable to think that's eventually going to happen.
Sue, the language in the power of attorney designates us to act on their behalf on customs entries and other things. So that's where we wonder, what do they mean by the designation? There's no definition out there. What are they designating? In the power of attorney designates us to act as their as an agent, not necessarily broker, agent, which means you have to be a licensed broker to be that agent. And so there's real challenges to the language that they're looking at. It's one of those ones we think as we're going along here and they talk about what regulations should be reviewed and removed, we're going to point to this one real fast because it's obsolete. And the second part of it is we have power of attorneys that may be 20 years old. Okay, they didn't have centers back then. They didn't have they had ports rather than districts as we were going through. The question comes up: does that invalidate those old power of attorneys? I'm going to point to you, Sue. I don't think it does. Those power of attorneys are still good. The person who signed it may not be there anymore, but the power of attorney that obligated that named us as the broker still should be in effect. And I just want to see if you could answer that question for me.
No, I agree with you, Dan, but I do think the question that presents itself is if you have a really old power of attorney that doesn't necessarily detail all of the powers that you would like to make clear you are authorized to do. For example, if you remember, I mean, we can go back several slides here. I'm old enough to remember when this was the actual power of attorney that was used. A lot of language has been added to clarify what brokers are permitted or expected to do. And you may want to look at these older powers of attorney and use them as a reason to reopen a dialogue with a client and see about getting one that clarifies in more detail what you're permitted to do. So I don't think that it necessarily, if you have a power of attorney, let's just say 5 years old, and we're not talking about a partnership now, I don't think it requires you to get a new POA, but you may want to.
Exactly.
But the point also is, look, one of the things customs is looking at is, if you're a broker, who are you billing? Who are you getting paid by? And this is where it's a particular problem if you're dealing with somebody small and they've got 2 or 3 companies and they don't understand if you want to pay from the company that has the cash, move it to the importer company and pay from there and document things correctly. So for those of you dealing with folks with smaller companies or through forwarders, this is a particular area to be concerned about. All right, so clearly what customs is doing is trying to check whether the broker's communicating directly with the importer. Are you working through a forwarder? Are you working through a sub POA? Are the records readily available? I mean, the most recent audit that I've seen, what customs did was they gave the broker a list of, I think it was 10 or 11 POAs and stood there while they went through their records to find them. The other thing that keeps coming up is the MID. To this point, I'm not aware that customs has actually articulated what it considers to be a best practice. And I know that there are lots of different sources of those records, but that is something else. When you construct the MID, can you point to where you got the information? More and more, this is between brokers and unlicensed persons. But also, I will tell you, if you're working through forwarders, one of the best practices is to say, making sure that you tell them not to mark up the duties, not to mark up the fees that you're paying, and certainly not to mark the brokerage charge that's being assessed. And also to make sure that they understand their obligation is to give a copy of the entry to the we're seeing this more and more now. I know I hear back from forwarders, well, we want to be able to mark things up, and there is a way to legitimately. We can have a discussion about that at some other point in time, but I will tell you, if you don't have a waiver letter in your file, customs is coming back and trying to blame you for the forwarder marking up your brokerage fees. All right, look.
Question on that?
Yeah.
The importer gives it, the issuer of the power of attorney gives us a waiver and instructions to bill that forwarder. Is it our responsibility to make sure the forwarder is not marking it up? I don't think it is. I think that the action that we're following their instructions to a T as their agent to bill the forwarder. We've told forwarders, make sure you're not marking it up, but we're not going to go back and back. I don't think it's our responsibility.
No, I'm not suggesting that you have to, but you do want to put it in writing that they should not because it's necessarily required under the regulations, But because when customs comes to you and says, well, why are they marking up? You can legitimately point to what you sent them and said, we told them not to. So that's the only reason for doing it. It's more of a self-protection for you than anything else. I think what's patently obvious from the bulletins that LA issued and from other experiences we've all had with broker management officers, it's difficult for them to understand how to apply the regulations to what you guys do from an operational perspective. And the message really is to get into one of these kind of reviews is very costly and very time consuming. The audit to which I was referring is of a small broker, and customs was there for 3 days. Now, I don't think they needed to be there for 3 days, but that's the amount of time that they were there. And fortunately, we didn't have to be there the entire time, but you can imagine the disruption to your operation. So when we talk about very costly, it's not just the cost of any consultants or attorneys that you have present, but it's also the disruption to your own process. All right. A couple of best practices to start the discussion about powers of attorney per se. Please make sure you have somebody knowledgeable or a small team, depending on your size, that actually oversees the POAs you're receiving. Are they accurate? Are they complete? Do they follow your written procedures? Which services do you need a POA for? If you have more than one form, which form should apply? If you can make it work with a single form, that's the preference, simply because that makes it easier. You use the same form every time. When you get a POA, have you gone through the process to make sure that your procedure for verification has been followed? If you need a certification, or if you need backup for somebody that's signed when they're not listed as a corporate officer, or maybe even if they are, have you followed that procedure? And also, are you looking at expiration dates? Are you looking at shipping documents? Because I can't tell you how many times we've seen situations where the name, just to make it really easy, will say ABC Co. Inc., and all the shipping documents say ABC Corp. Those are not the same company. And so if the shipping documents don't match the POA, who's catching that and when? Ideally, what you have is first that somebody checks that you have the proper written authority before you handle a transaction. If you can, I use the term electronic jail, meaning can you lock your system down so that the transactions cannot occur? But let's be honest, this shouldn't be something where you look at it once and you never look at it again. There should be a process that you're using where you're double checking as you go along. You know, if the company moves, there's an argument to be made that maybe you don't need a new POA. But certainly if the company has a new name, you need a new POA. Have you gotten one? Are there things going on with the name of the company that are different than what's on your POA? You need to catch that early. Because if you don't, there's a question about whether you're legally entitled to operate on behalf of the company. And certainly there's a question about the impact on you to be able to collect bills and so on. And we'll talk about that in more depth in a little bit. All right, we know that there's penalties. The issue becomes, for regulatory purposes, are you authorized to act on behalf of the importer? So there's a lack of responsible supervision claim to be made. Certainly from the forwarder side, there's a question about whether you're authorized as well. Although the remedy that the agency may choose if it elects to go forward would be different. Certainly, if you're billing party A, like I said, ABC Co. Inc., and the real name is ABC Corp., you're probably not going to be able to collect your unpaid fees and advances. And certainly we can all recall with a lot of pain the $8 million judgment against a broker in the Nike context, where part of the claims against the broker were the sloppy POAs. So the POA itself has implications beyond just the question of what customs thinks of them. Here's some examples of ways in which you get them. The POA form that we talked about in the regulations, which is at best advisory. There's some reference in Title 15. There's forms developed by companies. And then I think the one that everybody tries to use, which is the NCBFA form. But even if you use one of these forms, you have to make sure it's properly executed. There's information that both BIS and Census have published. And let's turn quickly to some of the challenges with POAs. It's all about who can sign. It's all about the duration. It's all about all of these issues and some more. So let's start with the easy one. Partnerships and LLPs, they're good for 2 years. Otherwise, until revoked or replaced. Who has to sign? Well, if it's a partnership or an LLP, it's the general partner. Who checks if the non-partner importers insert an expiration date? This comes up from time to time. Let me here talk about LLCs for a minute because there's a lot of confusion about them. I can tell you Customs doesn't understand them. I can tell you most agencies don't understand them. This has come up in a bunch of different contexts. Technically, an LLC may or may not be a partnership. Certainly under the tax code, it is presumed to be a partnership, but an LLC can elect to be taxed as a corporation. Best practice would be treat it like a partnership. Assume that the POA expires at the end of every 2 years. Use it as an opportunity to have another discussion with a client for client relationship reasons. The only other tip I will give you about all of these POAs, and you'll see this more than once on the slides, is even once they're expired, don't throw them out. You know, your record keeping requirement, whether you're an importer, whether you're a broker or a forwarder, is 5 years, in some cases longer. Keep them for a while. Make sure that if somebody comes in and requests proof that you had authority to act, that you've got it. Partnerships as a general proposition have to be signed by a general partner. With an LLC, you're looking for the managing member. One of the questions we got was if it's a small company and they don't have this, that, or the other title, can we use owner? The answer is no. The answer is they have a legal form of business if it is a sole proprietorship, so that you're having the owner sign, then it is a sole proprietorship. But otherwise, regardless of their size, they have a corporate form and they should be electing people accordingly. Now, California is unique in the sense that you can have one person hold all of the offices. That is not true in other states, but you do need to make sure you get a proper corporate title from somebody if it is a corporation. Certainly under the regs, if there's a change in partners so that you end up with a new legal entity, you need a new POA. Non-resident principles are the biggest challenge, as I said earlier. They're a challenge because oftentimes the documentation is not in English. Oftentimes it's not clear who is entitled or who is expected to sign. But I can tell you this, when Customs asks you for evidence of what you did to vet that POA for the non-resident principle, you better be able to give them documents, and it better have been translated into English. So what's acceptable? Articles, probably not. I mean, articles will certainly establish, regardless of whether they're resident or not, that some entity has been properly formed, but it usually will not tell you who's authorized to act on behalf of the company. Articles, business licenses, what else kind of depends on what's available and how quickly you need to get it and how quickly you can get it translated. One of the things that is done with non-resident importers is you get a corporate certification. One of the problems with them is oftentimes they aren't read carefully. And so the person signing the POA is also certifying that they're authorized to sign. That's not what you want. You also want to look at what the title is. There's a term of art that lawyers use called apparent authority. Did the person appear to have authority? So it's easy if you have some way to verify that they're a corporate officer. In the US, we think of that as a CEO, a CFO, and so on. We think of that in most foreign countries as being a director, a managing director, or so on. But you can have apparent authority even if they are a domestic corporation. You know, a lot of large companies, you're not getting a POA signed by the CFO or the CEO. You're getting it signed by an import manager, a vice president of compliance, and so on. What you can't do is accept a POA that says shipping clerk and have, you know, just not ask more questions, because that is not someone that would normally have apparent authority. When you are dealing with somebody outside the US, you clearly want to get this certification. LLCs, we talked about them a little bit in terms of their tax status. The NCBFA POA does have a certification. Whether it's an LLC, a corporation, you usually can validate the company's existence from a Secretary of State website. You do want to make sure you do that. You do want to make sure you keep that as part of your regular records. You do also want to make sure that with an LLC, you get a copy of the operating agreement. The reason you want that is because you want to know who's been named as the managing member. Now, in some cases, you can get that off a Secretary of State's website. You still probably want to get the operating agreement because you want to make sure that you know who was designated. The question at the bottom here is what happens if the names don't match? And that's really intended to cover not only the name of the entity, but also if you've got someone signing whose name isn't registered with the Secretary of State, you need some document to back that up. Very often that document takes the form of something that in the corporate world is called minutes. That does exist in the context of LLCs as well, but you want to make sure you have a document in your file that backs up the name of who signed that POA and whatever their status is. And this is the truth, whether it's a foreign corporation or a resident corporation. And if somebody signs as an officer, and you've gone on the Secretary of State's website, and they are not listed, are you just going to take it at face value? Probably not, and you probably shouldn't. You know, our recommendation typically is don't. Get something in writing. Now, I'm going to be the first one to admit to you, somebody giving you minutes, they could be made up, that's true. And so perhaps you want to have them certified by the corporation secretary. But you do want to make sure that you've got something in your records that backs up the person who's signing has the authority that they claim to have. And by the authority, I don't necessarily just mean that they have apparent authority, but they actually hold the title that they claim to hold. Now, that can sometimes take the form of a company power of attorney. We've seen that work, and if that's the case, that's fine, but you just want the backup. Sole proprietor has to sign on behalf of themselves. This DBA situation is one that gets a lot of people in trouble. If Sam Jones or Helen sign a POA that just says Sam Jones or Helen's Food and Service, Inc., and the DBA is not mentioned, you cannot make entry in the name of the DBA. DBAs are fictitious names. They are typically not filed at the state level, which is why checking a Secretary of State's website will not do it. It's not always readily available at the county level, and DBAs typically expire. So this is, again, one of those things you need to vet when you're having your team look at the power of attorney. How long is the period of time a DBA is valid? And working that in. Forwarders, we know, can get a POA. Customs brokers, we know, can get a POA and assign sub-agents. You want to make sure you get a copy of the POA from which the sub-agency is assigned. That should be part of your standard operating procedure. And frankly, I would suggest to you that that would be a step, regardless of how viable, well-known, and reputable the party is who's giving you the sub-agency. People make mistakes unintentionally. You just want to make sure you're covered. How much due diligence you do beyond that is unclear. There is an argument to be made that you don't have to do any other due diligence, but I would suggest to you that it's not a blanket situation. And certainly with the first POA that you're getting, if it's not a very large broker that is well known, perhaps a local broker that's very small, you may want to do more due diligence than you would with one of the large brokers. But there's no hard and fast rule here, and there's no best practice that anybody's going to be able to recommend to you. So this is all a question of what you're comfortable with. I do want to make mention of the fact, before we move on, that in the proposed broker modernization regs, there is the potential that Customs is going to revoke the ruling that allows forwarders to issue POAs. There's a lot of concern about forwarders and the relationships that is not limited to LA. This is a huge issue, for example, along the southern border. The concern is that the broker is captive of the forwarder, that the broker is not allowing the importer to have direct contact with the broker, that it is barring or prohibiting or at least impairing the broker from doing their job correctly. And Customs is looking for ways to eliminate those impediments to getting correct declarations at time of entry. There are record-keeping penalties. You're going to hear me say this more than once. Make sure you keep these records for at least 5 years. And if you're dealing with drawback or ADD or others, you may want to keep them longer. But you do want to make sure that you're keeping them for at least the minimum of 5 years. And again, that's whether you're a forwarder or a broker, the same record-keeping time applies. Again, keep all of the POAs, but the other point I want to make is please do not complete the POA for the importer or the exporter before you send it to them to sign. If you don't get the corporate name right, they're usually not going to catch it. They will just sign it. And if you screwed it up, however unintentionally it may have been, you're going to be on the wrong end of the situation. So I get the customer service desire to be helpful, but it's one of the things that will most quickly come back and bite you in the tush. Okay, get the name right. Get the type of entity right. You know, I'm going to go back to the ABC Co. Inc. versus ABC Corp. Is it a corporation? Is it an LLC? I've yet to see, and I don't know anybody that has seen a situation where calling it a corporation on the POA versus an LLC is necessarily going to create issues, but certainly having the wrong name will. The other thing that comes back and haunts everybody is this question about who signs the POA. And now I don't mean what is their title, I mean their physical signature. Because I'm in LA, I see a lot of these POAs come in, and we see a lot of folks, particularly in the Asian countries, where they have an anglicized name. So their name may be Zhang Li, but the POA gets signed Andy Lee. That is not a legitimate signature. You want their full legal name signed. So you need to make sure that that's what you're getting. Now, you know, you just need to do that. And that's why vetting the POA correctly becomes an issue. Now, I've had conversations with clients where I get an Andy Lee and they said, no, that is my legal name. Okay, fine. Validate that back to them, because otherwise the POA is not valid. You need to make sure that the shipment documents match. You need to make sure you have a procedure in your system where you're on some kind of a regular basis looking to see whether the client name changes. You know, a lot of times what happens is they forget to tell you. And, you know, you're used to dealing with these people, they've got new signatures, you're just clearing stuff. Nobody picks up on the name change. Nobody picks up on the address change. At the very least, with an address change, you want to make sure you do a 5106 update. But certainly with a name change, you got to get a new POA. All right, where they're registered or incorporated is relatively easy on the POAs when it's a domestic corporation or a domestic entity. It becomes much less clear when they're a foreign company. It becomes much less clear from both an address perspective and also how you just physically fill out the form. So just make sure you adapt the form so that instead of saying in the state of Pennsylvania, you know, it's now in the province of Shanghai, China. The question of how you validate the POA from the perspective of an address where it's a region of the country, and I'll think of the Middle East here as the illustration. You know, a lot of times there's not a proper street address. So do you get a Google Map set of coordinates? Do you validate them? If you can't find the location, are you then going back to the company to actually have them be able to point out to you where they show up on a map? Signatures. You got to make sure that on the individual or sole proprietor, it's the signature of the owner of the company. It's the sole proprietor. The partnership or LLP, is it the general partner? Is it the managing partner? Corporations and LLCs we talked about. Does the POA show the capacity or the title? Does that title make sense? You know, I can see that a CIO would be a person that has a corporate title. I'm not sure I would I'm not sure I would accept a POA that's signed by a CIO without asking why it's the chief information officer that's signing a POA having to do with importing and exporting. There seems to be a disconnect between the title and the function. Again, a foreign person signature is in English. What are you doing? Why isn't it in their native language? And then if it is in their native language, you need to think about whether your process is going to be that you will add to the POA their name in English characters. So to go back to my Zhang Li as opposed to Andy Lee, do you make sure that it says Zhang Li Managing Director in English on the POA that you've gotten? All right, a lot of people asked about e-signatures. We do not have an answer from Customs. The last thing we have is the 2006 ruling to which you see reference made on this particular slide. We do know from the 2002 ruling that fax copies do qualify as original records. So This particular 2006 ruling deals with the Government Paperwork Elimination Act, which does authorize electronic records. It deals with a particular section of the GPEA that does recognize electronic signatures. Electronic signatures are permitted under the UETA and under e-sign. However, those are both limited to commercial situations. You know, if the two parties to the contract agree, you can do this. The key out of the ruling was that the person's identity is authenticated by the procedures that are used, and that there are commercially available electronic signature products. Now, we know that in a lot of states where real estate transactions occur, and it varies by state, that DocuSign or some version of that particular program is quite popular and is used regularly. What I would recommend, and I said this to Cece before we started, so this is not going to be a surprise, is that you get with the association and the association vet a vendor for you so that all of you can use your buying clout jointly, and get, whether it's DocuSign or whether one of the other vendors, that they make it available to you for whatever fee they're going to charge at a usage rate that reflects your buying clout, and that you think about using one of the electronic processes. I think it's also important to understand that that may be a solution without a problem, meaning that fax signatures are still accepted. I think the advantage to doing this through a commercial vendor is that it at least gives the impression that there's been more effort put forth to validate the identity of the person signing. Doesn't change the need to do all of the other things, but I do think it's going to come to the point where at some point Customs is going to say, well, how did you know the person who signed is the person that should have signed? Because frankly, we've all seen evidence of documents that have been signed electronically, and it could have been signed by anybody. You know, somebody asked, can I use a squiggle if that's what I receive? And the answer is probably not. But if you've done what you're supposed to do, which is you've asked that person to produce something else for you, which shows a photo ID, a passport page, something along those lines to validate that they're a real person, if you look at that document and the signature on it is a squiggle, then that's their legal signature. You know, I have a signature, for those of you that have seen it, that is chicken scratching, but that's my signature, and that's the one I use on everything. Now, I would mention here that this is also where you have to think about the fact, once you've got a driver's license or a passport page, that you've got personally identifiable information, and you have to think about the cybersecurity consequences of that. But Customs did at least go to the trouble of publishing some recommendations. Some of them are more realistic than others. Yeah, we all know it would be ideal if you could have a POA completed in person, but how often is that the case? Yeah, we know that you're supposed to get the domestic violence IRS number, the employee identification number that's been assigned, or a social security number. The social security number, of course, again, personally identifiable information, who has access to it, how easily can it be obtained? Yeah, we know you're supposed to get in and check state websites. As I said earlier, the registered DBAs typically are not registered with the state. They're issued at the county level. So, you know, going to a state website doesn't help. Public mapping programs, this is the Google Maps issue again. Searching company websites, you know, Customs can't get it through their heads that people don't always use company websites when they travel. But the point is, what are you doing to validate the information you're getting? All right, check the BIS consolidated screening list. Make sure that you've got some backup documents in your files. We got a question at one point about, if the address changes, do I need to do an update on the POA? I think I covered that earlier. No, but you probably want to do a 5106 update. But if you do run into these disconnects between information on a website and information in your records, you know, who's picking that up and what are you doing with it? Because it's really just all about showing you vetted the information. We've got this certification when it's a non-officer who's signing, somebody that's signing a non-resident business. There's also this question about divisions and branches. You know, if you've got a POA from the principal or the mother company, you can't do business on behalf of the divisions or branches unless you have POAs from those divisions or branches. Again, no blank fields on the POAs, legal signatures, and again, if it's not in English characters, do you add them? What about the anglicized versions of names? When you're looking at certifications, you have to read them carefully. You have to keep in mind that the corporate titles are different. More important than anything else is what do you have in your policies and procedures? Have those been followed? Again, we know that witnesses, notaries, and seals are no longer required, but are you, what are you doing? What are you requiring? Make sure that whoever's in charge of getting the POA from the customer keeps good notes. Make sure those notes are dated and make sure they are part of your permanent record. Now, I've harped, as probably every lawyer that you've dealt with has harped on the importance of keeping notes. I'm not naive enough to think it wasn't difficult enough when we all had actual paper files, and that it's far more difficult now. But with the advent of emails, it's really, in a sense, much easier to get these records made and kept. And it just has to, you have to be sure that this doesn't become part of your normal, well, we dump our emails every 30 days or 60 days or whatever it may be. These are critical documents that need to be dealt with differently. And that's why having a team that focuses just on POAs is really critical. Other than the three different regulations that are cited, we have no instructions from customs. We got a lot of subjective things that customs wants you to do, but nothing that's very clear. So you want to make sure you have a complete set of written procedures. You want to check that with whoever you use as your outside consultants, that they have vetted this for you and that the attorneys approve what this process is, and that you implement these procedures, that you monitor these procedures, that you use them on a regular basis, and that you update them as appropriate. This is the list of the most common errors we have seen. It's misspellings, it's failure to designate, it really comes down to somebody just got the form and put it away without looking at it. And so vetting it when you get it and having a routine where it's vetted on some kind of a regular basis, whether it's once a year or more or less frequently. You know, many of you have regular conversations with your customers about what changes they're making to their processes and procedures. Add to that just very quickly. So any changes in your corporate structure. You know, we had a whole issue going with a client recently where they filed an application for an FTC subzone, and we had to have a conversation about at what point customs got notified that all the various names they were using had been consolidated or under one name. And that became a big issue because we didn't want to hold up the approval and we didn't want to confuse anybody in that process. All right. The NCBFA has a good set of instructions. Most of you use them. There are new regulations in the works you want to be sensitive to. You want to make sure that you, obviously, and I've said this now probably for the fourth time, somebody needs to check that you have a valid POA before you start working for a client. But I don't mean that literally only then. And to the extent that you can manage the compliance electronically, you want to. So at the beginning, you may not set the client up as a customer in your system until you have a valid POA. But you may want to also have an electronic reminder in your system to have somebody go back and look at the POA on some sort of a regular basis, if for no other reason than, as I've said earlier, to document that what you have on the POA matches what's going on at the shipment level. And then lastly, what I want to do is just for emphasis point out that oftentimes what you do, and we've seen this with any number of brokers, not only do you get the NCBFA terms and conditions acknowledged, but there are also perhaps waivers of confidentiality that are included. And I'm going to talk about this. I'm going to ask Colleen to join me in just a second, Colleen Clark. But you know, credit applications and personal guarantees are often individually signed, but waivers of confidentiality, acceptance of NCBFA terms and conditions are often done through the signing of the POA. If the POA itself isn't properly executed, then the terms and conditions and the waivers and the other uses that you make of the POA may be equally not valid. So Colleen, you and I had a conversation the other day about a couple of things that would be helpful for the sureties to have in the POAs. And so if you could just take a minute and raise those so that everybody's sensitive to this issue, because particularly in these difficult financial times, there are a lot of companies going under, and it's creating, as you can imagine, a lot of complications.
Sure. Thanks, Sue, for reaching out to me earlier this week. So one thing that we have talked about regarding the broker POA, the standard language that brokers use, is considering adding some language allowing you as the customs broker to receive all surety data for if you are the broker of record on a continuous bond. Surety companies obviously receive all of this information from customs through our automated surety interface, and that's available to our broker clients, right? We can send that entry information out. The problem comes up when you procure the bond. You're the broker of record on a bond, but other entries are filed. Entries are filed by other brokers under that particular bond. So we have to just click through in our system that you acknowledge that you have authority from the importer to receive this information, but it is something that you may want to consider adding into your power of attorney, just as added comfort for you that you're able to receive entry information where you are not the filer. We're restricted based on our interconnection security agreement with customs, the sureties are, and it cites the Trade Secrets Act, so we have to protect this data, and we're just relying on you guys to provide that you have authority to receive that information for your importer clients, in particular if you're doing all their compliance work. And one other just really quick thing is reconciliation. We have had instances, in particular in the past year, with a lot of companies that have gone out of business, where we've had to hire an attorney to work on reconciling those entries that have been previously flagged, and a company's bankrupt, there's nobody around, so we hire attorneys to do that for us, and we sign, we need a broker to file these recons for us, so we go back to the original filer, and the sureties will sign a power of attorney to allow for you to act on our behalf in filing these recons. Otherwise, we're going to be stuck with those penalties. So just a couple tips I wanted to add. Thank you, Sue.
Thanks for including that, Colleen, and hopefully the Customs Committee can take that up, because I know that from time to time there are discussions about updating the POA form that the NCBFA issues, and so sensitivity to some of these real-world complications are particularly important. Now, I managed to get through all of this with 5 minutes to spare. Cece, I'm open to, I think I covered almost all of the questions that we had gotten. I will say somebody did send in one question about POAs that I didn't cover. And that was that they had gotten a POA from a trucker who did not appear to be the bonded carrier for the move. And they wondered if the non-bonded carrier POA was adequate. And I would suggest to you the answer to that, and Colleen, you may want to chime in here, but I would suggest to you that the answer to that is no. That if you're going to move goods on behalf of a bonded carrier, you want that bonded carrier to be a party to all of this and not just some trucker down the line.
I would agree with that.
Yeah. Okay. The other question that I think is worth talking about is, we got a question that said, we're going to issue a POA to our employees, as all of you are obligated to do. And does that need to be an individual POA to each employee, or can that be a list? To my knowledge, we don't have any guidance on that. And so my answer on that question would be, please check with your local broker management officer. I would certainly hope that they would accept the list. But let's just say, given the challenges that we have and the lack of uniformity, it's probably worth asking that question and see what they'll take. And of course, even if they will take a list, you clearly need to update it in accord with the regulations. All right. We have a lot of people on this webinar. Hopefully we've answered most of your questions, but if you have a burning question you'd like to ask, now would be the time to do it. If you think of any additional questions after we get off by all means, please send them to Cece and we'll be sure to get answers back to you. The other thing I will do, I think I may have already said this, but let me just make sure I do. The two LA bulletins that Dan was so instrumental in, well, not instrumental in getting, but instrumental in getting corrected to the degree we can call it corrected. I will make sure that Cece gets copies, and we'll get that out to all of you. But otherwise, unless anybody has any burning questions, I don't see any.
Oh, Sue, I didn't give you the rights to see them. There are a lot of questions.
Oh, I'm sorry.
I'm going to go ahead and make you an organizer so you can go ahead and see them now if you want to read through them. Some of them came in during the webinar. Do you see them now under the question box? And I can go ahead and read them if you want as well. I mean, I can.
I'm not seeing them real quick, and I don't want to hold this up too long.
Okay. Do you want me to read you a couple, or you want to just? There are several, so if you want me to send them.
Just start at the beginning, and I'll tell you what. Let's do this. It's 10:58. Why don't we just go through, let's say, 10 minutes of questions?
Okay.
And whatever we have left, we'll make sure everybody gets answers.
Okay, that sounds good. The first question is POA required to add 5106 for ultimate consignee? This is when you have a non-resident importer and you need to add records for the U.S. consignee.
So where you have the non-resident importer, which is usually a DDP transaction, and you have an ultimate consignee, so you need their IRS number, you're not making entry on their behalf. So I don't think a POA is needed. You certainly need their IRS number, and getting that can be a challenge, but I would say no.
Okay. Is the service of preparing and presenting a carnet to CBP for cargo release considered customs business, and is a POA required?
I'd have to think about that one. My gut reaction is no, because you're really just taking a form and giving it to customs. And I don't believe, and Dan, maybe you can help me here, I don't believe carnet requires a broker.
Okay, I'm unmuted now. Carnet, you only need a power of attorney if you're signing the form. If you're named on the carnet as a party, then you're okay. You don't need a power of attorney because they name the forwarders and players on the carnet. But if you're not named on there and they ask you to submit it and you need to sign it, you need a power of attorney to put that signature for whoever you're signing for.
Yeah, I think that's an important point, regardless of the context. If you're being asked to sign on behalf of somebody, depending on the context, you may not need a full-blown power of attorney. It is the best option is to get one, but at the very least, you want some sort of written authorization. Yep. What's the next question, Cece?
When a company changes names, if they do not change their IRS number, I believe a new POA is not required. We obtain copies of the legal name change documents. Is this correct?
I would get a new POA, and I would do that for a couple of reasons. First of all, and most importantly, it eliminates a lot of explanation and time. But second of all, you have a POA that's not in the legal name of the importer of record. And you want to make sure you always have your POA in the name of the importer of record.
Okay. Did you mention that you suggest LLC POAs are set to expire within 2 years as well as other POAs?
I did, yes.
Okay. Can an email from the company be used to verify authority of who is signing?
Say that again?
Can an email from the company be used to verify authority of who is signing the POA?
My gut reaction is no, because anybody can send an email. What you want is some kind of an official document. So at the very least, if you've looked at the Secretary of State's website and they do not include, let's say, who all the vice presidents are, then you want a copy of the minutes at which somebody was elected as a vice president or appointed as a vice president, or some kind of document in your file, but not just an email.
Okay. Will corporate certification be required for non-resident importers if they only have one officer? The corporate certification requires 2 officers, but what is required if there's only one?
So let's talk apples and oranges here. When I talk certification of a foreign importer, I didn't limit that certification to a corporate officer because you can have managers that are not corporate officers. So the certification for a foreign company would be someone with apparent authority. So you might, for example, have the shipping manager, a manager therefore with apparent authority, certifying that someone is the managing director. I mean, look, the best of all of these options is to have the documents that name this person to a specific title. Those are not always available, and even if they're available, certainly with foreign importers, they may not be in English. And so what we're really talking about is if you can't get the ideal document, what's your fallback position? And so just remember, apparent authority works really well.
Okay, thank you. Who is responsible for translating a foreign business validating document, the broker or the entity providing the document?
Well, in an ideal world, your customer provides it to you. And when I say translation, I don't necessarily mean that the whole thing has to be translated. I know we've seen a lot of situations where we've said to the client, look, we need this tomorrow. Translate the most important things and we'll deal with the rest of it later. And so they'll translate the most important things, which will be obviously, the name, the address, the authority, and so on. But ideally, they do the translating and they give you a complete document translated. Now, ideally, what that means is somebody has actually translated it and you've got a certification from the person who translated it. In the real world, what usually happens is somebody on the team speaks English and they handwrite over it. And I recognize that that's often what you're going to get. But you want them to give it to you in English. You don't want to be the translator.
Okay. Is a POA required for the filing of 7512/IT?
That's an old issue. And I think the answer is going to be, as a general proposition, no, because carriers can themselves file the 7512.
Sue?
Yeah.
The answer is 7512s are not customs business.
Right.
So that's what you need the power of attorney to certify it, but it's good to have, you need authority to be able to sign for them. Doesn't necessarily.
Well, that's where I was going with the but, Dan. This is again a situation where if somebody's asking you to sign their name, then you want that POA. And again, whether you actually want a full-blown POA or whether you want written authorization is a different question. But you certainly do want to make sure that if you're signing anybody's name other than on behalf of your own company, that you've got something in your files, and preferably you just get the customs POA and don't worry about it. But that's not always going to be practical and not always going to be something that can be easily done.
Yeah, the challenge is when you've got just a one-time deal for a trucker and it's got to go tomorrow. I need something in writing saying authorize you to use our bond for this in bond, and you can sign for us.
Yeah, and that's where, frankly, getting an email and then just responding back and saying, got it, we'll take care of it. Because that way you've got it in your files, you've acknowledged it back. And if it really somebody's sending it by mistake or whatever, we lawyers are going to say, well, we acknowledge it back. If it was wrong, you should have said no.
Okay. Can a POA be backdated?
Absolutely, unequivocally, no. Now, here is what I mean by that, because it's not exactly a precise answer. You never, ever, ever want to be in a position where somebody signs a POA today and they put last month's date on it or even yesterday's date on it. But if you are in a situation, and we've seen this happen with situations where, for example, and this is going to be an easy one, it's ABC Co. period, comma, Inc. period. And when the POA got done, it was ABC Co. Inc., no periods, no commas. We'll do a new POA that says ABC Co. period, comma, Inc. period. They'll sign it today, but there'll be language above it that says, this replaces a POA that was effective X date. If you are talking about getting a POA to cover back work and you didn't have the POA, you are out of luck.
Okay, thank you. We have time for a couple more questions, and then there are several that came in. I will pass these on to Sue to make sure if your question, we didn't get to it, I will pass it on to her. So the second to last question that we're going to take today is, in the event the confidentiality waiver is a separate document, should the signer be the same as the grantor of the POA?
Look, that's the easy answer, but it doesn't have to be. As long as and we've seen this happen where, confidentiality goes one place, POA goes someplace else. Oftentimes the confidentiality waiver goes to the legal department. It doesn't have to be, but again, as long as it's signed by someone who has apparent authority, you're fine.
Okay, thank you. Is the title of owner a valid title to sign a POA? Is there a list of acceptable titles for all types of companies?
So the answer is no and no. You're not an owner, you're a sole proprietor. If you're not a sole proprietor because you formed a corporation, you are the president. So owner is not an appropriate title under any circumstances. And in terms of what the accepted titles are, there is no list anywhere, but as a general proposition, if it's a sole proprietorship, it's a sole proprietorship. If it's a sole proprietorship with a DBA, it's the sole proprietor doing business as whatever the DBA is. If it's a partnership, LLP, you're looking for the general partner. If it's a corporation, you're looking for a corporate officer. If it's an LLC, you're looking for the managing member.
Okay, thank you. And we'll take this one last question. Are brokers allowed to charge a fee for outlaying the duties on behalf of the customer?
Okay, that is not a POA question, but the answer is there's nothing to stop you from creating whatever fee schedule you want to create. And I will tell you, when I was a broker way back in the good old days, we actually charged a percentage of the value. You can't get away with that anymore. But certainly if you're providing banking charges, why not? Or what would otherwise be banking services, why not?
Okay, thank you, Sue. Thank you for everybody who stayed on the line. Most of the people stayed on.
Yes.
Thank you for staying on late, and thank you, Sue, for staying on late and for putting together this excellent presentation. I will get the other bulletins that Sue mentioned, and I will send that to everybody that was on. I will also pass along all of the questions that we didn't get to make sure that you get a response. Please be patient with us as we do get a response. I can't promise you that you'll get a response today, but I will make sure that you do get a response. We really appreciate all of your time and efforts in putting together this presentation, and everybody for joining. And Sue, I don't know if you can see, you're getting a lot of great feedback in the question box. So everyone appreciated your presentation. So
thanks, guys.
Thank you, everyone. Enjoy the rest of your day, and look out for a follow-up email from me soon. Enjoy the rest of your day. Bye.
Everybody take care. Bye-bye.